Welcome to today's webinar, MAP-21 and Traffic Safety, Incentive Grants for the States webinar, brought to you by NCSL. All lines have been placed on a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to Ann Teagan. Ma'am, the floor is yours.
Thank you, and hello. Welcome, everyone. Good afternoon, and welcome to the National Conference of State Legislatures webinar, MAP-21 and Traffic Safety, Incentive Grants for the States. On July 6, 2012, the Moving Ahead for Progress in the 21st Century Act, or MAP-21, was signed into law by the President. Included in MAP-21 is a section entitled the National Safety Priority Programs, which aims to advance a number of traffic safety-related programs by providing grants to states if they adopt or have adopted certain provisions. Grants are available for programs that involve occupant protection, traffic system improvements, impaired driving, distracted driving, motorcyclist safety, and graduated driver's licenses. To provide us more information about the National Safety Priority Program, we are honored to have two distinguished speakers today. Our first speaker, Dr. Mary Gunnels, is the Associate Administrator for Regional Operations and Program Delivery at the National Highway Traffic Safety Administration. Our second speaker, Barbara Harsha, is the Executive Director of the Governor's Highway Safety Association. At any time, if you have a question that you would like to ask a speaker, please type it in the chat box. And after both speakers have given their presentations, I will read the questions and provide an opportunity for the speakers to answer. So now I will turn things over to Dr. Mary Gunnels to discuss the National Safety Priority Program in more detail and give us a timeline of program requirements. Dr. Gunnels, the floor is yours.
Well, thank you, and thanks so much for having NHTSA as a part of this really exciting webinar. We're broadcasting to you from Washington, D.C., and it's a sunny day here, and we're just delighted to be here with you this afternoon, or maybe for some of you this morning, so thank you. So we have, as you know, a new authorization for our Highway Safety Program, and today we're going to talk about just a general overview and highlights of the programs. And we're also going to spend a little bit of time focusing on some issues that are important that are new and important, and that includes the performance measurement. So we'll talk a little bit about timelines, some of the priority program areas, as well as these performance measures and where we are with implementation. And then our colleague, Barbara Harsha from the Governor's Highway Safety Association, is going to speak to the points regarding key safety legislation and where you can help with that. And so now let's go to Highway Safety Program implementation date. Next slide. I think many of you are familiar with these dates, but we wanted to spend just a moment and talk to you sort of about the short term with regard to MAP-21. One of the important things to remember is this is a transition year, if you will. We had obviously the law enacted last summer, and NHTSA moved very quickly to publish an interim final rule so we can implement these programs, and that was published in January of this year. We have just come through the first deadline for applications by the states and jurisdictions for these grants, and that was March 25th. So right at this moment, we are evaluating grants for award determination. We also have a comment period open on the interim final rule, so if NCSL and any of you are interested in providing comments, we welcome that, and that deadline is April 23rd in the docket here at NHTSA at DOT. And we anticipate, pending our receipt and availability of funding, making these awards for this first year, which is FY 2013, in May. The challenge for the states in particular has been that we're actually doing effectively 2 grant years within a very short period of time. The next set of applications for FY 2014 come due on July 1st. So that's an important timeline, and the states have been really wonderful working with us to get their applications in. And I'm happy to report that every state and jurisdiction made application for FY 2013. And then in July and September starts what will be the annual cycle for the NHTSA Highway Safety Grant Program. So we can turn to the next slide on the overview. Just a couple of points to highlight. These are fairly large programs, as you can see by the funding levels. There were some grant programs that have changed or been eliminated. We have moved to a consolidated program with 2 NHTSA grants. We have the traditional, if you will, Community Highway Safety Program, the State Community Highway Safety Program, which is the 402 base funding for states. And we also have the 405 programs, which are the priority areas Ann mentioned, occupant protection and such, which we'll talk about in a minute. The thing to remember is that over these many years, these grant programs had different timelines. So they actually had timelines that extended throughout the year, starting in February. So the states used to have to do all these separate applications. So as we come to July 1st of 2013 and start this new annual cycle, all these applications will come due at the same time. We have 3 new grants programs. We have distracted driving, graduated driver's licensing, and we have an ignition interlock program, which is within the impaired driving program that we'll talk about. And certainly Safe TLU was repealed in terms of the other sections, and there was a grant program that was eliminated. That's the racial profiling grant. And just a note, it does affect the states in terms of our work with our colleagues through FHWA. We do have transfer programs, and those are the 154, 164, and we've made some changes that we hope will make it easier for the states. So the next slide talks about just the funding levels and the different programs, which we've already talked about a little bit. So here you can see the different funding levels. It's an unusual year in that we already had received apportionments for part of the Section 402 program, and that was about 48.6% of that program has already been distributed to the states. And we do have part of our funding already for the occupant protection program, but again, this is a transition year. So the funding will become available soon for FY 2013, and we can move forward to make these awards for the remainder of the program. So here you see the different funding levels, and these are all the Section 405 programs specifically are the programs that we're evaluating right now, the applications for award. We can turn next to the Highway Safety Plan highlights. There's a number of changes that are very positive for states and for traffic safety in general with regard to the Section 402 Highway Safety Plan criteria, if you will. The NHTSA has worked with the Governor's Highway Safety Association for many years, working together on how to improve program planning and on the development of consensus performance measures, which we'll talk about in a minute. But there were also some important changes for the highway safety planning process. Also, we had some flexibility in the 403 research and demonstration program area, the projects, where we can have some flexibilities between the core highway safety program funds and 403 that weren't there before. In other words, if we had additional funds remaining from one program, we could shift them to another area of need. Also starting in FY 2014, we have some new procedures and the new measures for the highway safety plans. And we're going to talk again about, as I mentioned, about these measures in a minute. But these are things like, these are things that go beyond the fatalities and injuries. They're the behavioral safety measures we use. And so those will be required starting with the FY 2014 year. So these performance measures have been used really since FY 2010 voluntarily by states, but they'll be required after July 1st. There's some other additional planning issues that have been addressed in terms of data and analysis supporting countermeasures, the evidence that are used to determine whether or not the highway safety plan is going to be effective or that the programs are effective, and the description of all funds that are used for these programs. And NHTSA does review these highway safety plans and has the ability or the authority to not approve plans if the program criteria are not met or the program outcomes are insufficient. So let's start by taking a look at occupant protection. So this is one, of course, of NHTSA's cornerstone programs where a lot of progress has been made in terms of safety over the year. And these grants have always had, they've always been essentially incentive grants, although they're non-formula grants. And the way under the new MAP-21 program we're going to examine states is whether they're high seatbelt use rate states or whether they're lower seatbelt use rate states. And essentially, the high states have a number of criteria, and they're required to meet at least 3 of the 6 criteria. And while not getting into the specifics, those are things like whether or not the program has been assessed, the existence of a primary seatbelt law in the state or not, and the enforcement levels in the state. So those, I'm sorry, I misspoke for just a minute. What I'm talking about right now are the lower state qualification criteria. So for this program, there are a number of criteria for the lower seatbelt use rate states, and those are some of them, and states are required to meet a number of those. And then the criteria might be different for the high seatbelt use rate state that has an occupant protection or a seatbelt use rate of 90% or higher. So just to tell you that there are a number of criteria for these programs, and that's what we're looking at right now to see whether or not a state can qualify. Let's turn next to the data program. So there is a grant program that really works with states to improve the data systems related to traffic safety. These are geared so that states focus on quantifiable, measurable improvements in safety data. There are things, obviously, you're familiar with FARS and our NHTSA data systems. These programs can fund a variety of things, such as analysts to support the FARS system. But the states have to meet a set of criteria, and they have to demonstrate that they've had measured progress in improving their data systems. And it also encourages states to improve the compatibility and the interoperability of their own state data systems. And as we all know, there are a number of different systems that states use when they're looking at traffic safety issues, whether it might be emergency medical services or trauma or some state traffic safety systems. So that's what these grants are for. And actually, I think almost every jurisdiction applied for these grants, and these really form the cornerstone of the state's ability to collect data. And if you turn to the next slide, let's see. Oh, here we go. I just want to make sure I was on the right slide. There were a couple of changes in this program, and this is the program that also relies on a TRCC, which is a Traffic Record Coordinating Committee. TRCC, and there's some specific criteria about the composition and the function of that committee. It's very important that states have an active group that helps manage the data systems and looks toward improvements of the system. And for any of these programs, including occupant protection, which we've talked about, and some of the others that we will talk about, NHTSA does have an assessment program that we use to go in and look at whether or not a state is making progress or how a state can improve. And that is a requirement of this program. There's also some new flexibilities in terms of what the assessments are, what they look like. But that's another element of this data program. So the next slide talks about impaired driving. And impaired driving is one of the largest programs we have. It's one of the largest traffic safety problems we all face. And it's somewhat complicated because there are different elements of this program. So we'll just take a minute to talk about a couple of the, I guess, highlights, if you will, of the program. This used to be called the 410 program. NHTSA uses FARS to determine alcohol involvement in crashes and any of the alcohol-related traffic safety measures we use. And we rely on those measures to determine whether or not states are in a high range, mid-range, or low range in terms of their alcohol involvement or alcohol-involved crashes, if you will. I apologize, I'm not saying that quite right, but anyway, I'll clarify that in just a sec. There's also a piece of the program that's very important, which is new, and that is the ignition interlock program. And so whether or not a state has enacted an ignition interlock law will qualify them for that piece of the program. So the next slide gives a little more explanation on the rates with regard to determinations of the low, mid, and high range states. And here you see we're looking specifically in these states at fatality rates. And so when we look at the fatality rates, we identify what area, what range the state falls in, and then we evaluate the state based upon that, whatever criteria they fall within. Again, I think I mentioned that NHTSA uses FARS generally for most of these data qualification issues. And when you're looking at the regulation and when you're looking at the statute, if you see something that says NHTSA will determine or NHTSA determines, that means that when we are making data-driven decisions, we use NHTSA data. So the state must participate in FARS and our national data systems. And finally, this ignition interlock law is very specific, and it requires, and I'm sure Barbara will talk a little more about traffic safety laws and opportunities for states, but this is about laws requiring convicted offenders to install an ignition interlock device for at least 30 days. So there are some very specific requirements to this law. There are a couple of other things before we turn to the motorcycle program just to keep in mind. I think I mentioned that we have more flexibility between these grant programs, and not only with 402 and the 403 Research and Demonstration Program, with the 405 program, if we were not to fully expend all the funds within a grant program, NHTSA has the flexibility to redistribute those funds. Though we haven't determined how we're going to do that yet, that's something that will come into play in a minute when we talk about some of the other programs. And there are also some new congressional reports, as well as a new teen traffic safety program that's allowed. So there are a lot of nice new additions to the 405 grant programs. So let's turn next to distracted driving. And distracted driving is a new program. We actually approached this program differently for FY 2013. So in case last summer you saw that we published a Federal Register notice calling for applications for this program. The reason that NHTSA and the department opted to do that is that this was a high priority program which we wanted to move out on very quickly. As it turned out, we weren't funded at that time, and so we extended the deadline for the FY 2013 applications to February. And I tell you that it's the same. It's not the same program for both years. We'll talk here really about the basic criteria. But right now we have the applications for the FY 2013 program that we're looking at in conjunction with everything that was received on March 25th. And then when you see us look at applications or evaluate applications for FY 2014, we'll be looking at all the programs together at that time. But in case you're wondering why we published notices and extended a deadline, it was because of the priority nature of distracted driving. It just wasn't funded. So to comply with this program for this year, the state must have a primary texting ban for all drivers and a cell phone ban for young drivers. There's some minimum fines, and this looks like it fell off a little. Oh, no, it didn't fall off. It fell off much. Well, it should say increased for repeat offenders. So there's some specific language related to repeat offenders. There's some emergency exemptions. And then there's some restrictions or some limitations on what the grant funds can be used for. And at least 50% must be used for education, science, and enforcement, and then up to 50% for behavioral safety-related programs. And in this grant program, because of our uncertainty as to how many states would apply and how many states would qualify, we do, with this and other programs, have a 10% cap on the awards for the program. And that's important because when you have a program where we may not have as many states apply, we may have extra funds, and again comes into what I mentioned in terms of the ability to move funds to other priority program areas. So next up is motorcycle safety. And this is one of the grant programs that's very similar to the prior grant program. It's largely unchanged from the Safety Loop program, and the territories are not eligible for this program. And it really is about effective programs that rely heavily on education and awareness and motorcyclist safety issues. So it's one of our smaller programs. Yes, it's a really critical program because motorcycle safety is such an important issue in the state. Let's turn now to GDL, Graduated Driver's Licensing. All right, and so you can see here the definition of GDL is right up front, and this really involves this multi-stage process. And it seems, if you're reading the IFR and if you're looking at the statute, it seems a little complicated, but it really does look at the stages specifically. I think the way to think about it is that it looks for the stages specifically that address driver's licenses for young or novice drivers. And again, it's an incentive grant program. It's a non-formula grant program, and there are some minimum qualifications that are specified in the legislation, in the regulation. And I think one of the hopes of NHTSA is that states will seek to improve their laws based on the criteria you'll see in the interim final rule. This was a part of the prior transportation reauthorizations, particularly T21, but it was eliminated in safety lieu, so now it's really been reintroduced. So it's a great program to introduce or to work on traffic safety issues in our young and novice drivers. Now, and here you see this slide, which looks at some of the specific requirements. It talks about the stages with regard to the learner's permit, the intermediate stage, and here you see some of the criteria for those stages. And as you can see, both stages have cell phone restrictions and conviction-free requirements. Conviction-free requirements. And so again, I think what NHTSA would like to see, as many of you would, I'm sure, is that we seek to improve our laws with regard to young and novice drivers. So let's turn for a moment to performance measurement. So that's the next slide. And this is a publication that I hope many of you have seen. NHTSA publishes many traffic text summaries of our research. And so this looks at the traffic text that was published at the time when the traffic safety consensus performance measures were published, which really dates back to 2008. And the goal of the performance measurement program, or these consensus performance measures, is really to measure states and measure state highway safety programs against themselves to determine if progress has been made. So it's a little bit different than a scorecard or some other type of measurement program. We're really looking year to year at how states set targets and whether or not they've achieved progress at the state level from the previous year. These are evidence-based, and we'll talk about some of the criteria. And because this really started in 2008, these measures have been used by most of the states and other jurisdictions since FY 2010, so fiscal year 2010. But the change is that effective July 1st, 2013, these are required by statute. So NHTSA is in the process of developing some tools to help states report these consistently, and we are excited about the opportunity to look at the trends and help the states improve target setting. And I'll just add that we are working collaboratively with our partners at the Federal Highway Administration and the Federal Motor Carrier Safety Administration on the performance measurement issues. And the next slide talks about the measures themselves. I think this one is the overview, and then in a minute we'll talk specifically about the measures. But here you see there are 10 core measures. These are traffic fatalities, serious injuries, fatality rates, and then a number of behavioral measures. There is a core behavior measure, which really is observe seatbelt use for passenger vehicles. And then there's 3 activity measures. And again, I've mentioned that this has been in discussion, was really created a number of years ago. And as Barbara may say, we just met with the Governor's Highway Safety Association and had another discussion about taking a look at these measures as we would do on an ongoing basis. And let's go ahead and turn to just a couple of more comments on it, and then we'll look at the measures themselves. So we'll turn over to the slide that says 52 jurisdictions. So you'll see, of course, our scope of authority, if you will. The primary data source for all of our measures is FARS, the serious injuries and observed belt use come from the state crash data files. And what you see in the third bullet is traditionally how we've looked at these consensus performance measures, which are 3-year averages. However, I believe we're moving to 5-year averages, and we'll be doing that in partnership with FHWA and FMCSA. So I also wanted to mention one other note about the performance measures in that you'll see the 14 or so that we're going to talk about. However, many states select more measures than this, and we certainly encourage them to do so. So here you see the actual listing of all the measures. And as we've talked about, fatalities, serious injuries, fatality rates, and a whole host of other measures from speeding-related fatalities to observed seatbelt use. There are activity measures which really look at the programs that NHTSA delivers, and those are things like looking at certain times of year during our crackdowns and mobilizations, at arrests, citations for belt, speeding, and other citations. So the 3 main activity measures are belt citations, speeding citations, and DWI arrests. When these were developed, there was a discussion about some developmental measures. So I just wanted to make a brief comment on these. The speed monitoring measure really was not going to proceed. The consensus was that the speeding-related fatalities was the best measure. There's a lot of work in progress on injuries. As you all may know, it's such a challenge to collect injury data, and there are a number of different ways to do that. So that work is in progress. States do attitude and awareness surveys to measure the effectiveness of their program, and you can see those. If you take a look at, say, the Office of Traffic Safety in California, they publish the results of their surveys, and they use that information. And then again, it's the enforcement activities that we talked about in terms of what's happening when we do a crackdown or any high visibility enforcement activity. The next slide just mentions countermeasure selection, just to kind of sum up the performance measure discussion before we wrap up with the last couple of slides. And these are a couple of the other publications which you may have seen. The publication called Countermeasures that Work is a really useful and important document that the states use. And it's being updated right now, and in fact, I would expect the updated versions to be released very soon, perhaps this month or very soon. So that's going to be a great resource for everybody. So it is required with the new program that states must set targets, and they must use evidence database strategies for their programs, and the consensus performance measures will help us monitor that. And then finally, just there's another very important piece of the new programs that is related to the highway safety planning process and the performance measurement, in that we are requiring states to be able to align their projects with the funding for a program using these measures. And so that is a new requirement. And we could talk more about that if you have questions, but that's an important goal. Not all states are able to do that at this time, but about half the states are able to do that within our grants tracking system. And then we're looking at ways to move all the states in that direction. And let's turn to the last slide that I have, which is just a mention about the coordination. We are working very closely with our partners at FHWA, FMCSA, and we're trying to ensure that we align the setting of targets and the use of these consensus performance measures. And this is in particular for the fatalities, the fatality rates, and the serious injuries. So we are doing that. We're hoping that that will significantly improve, certainly our communication with the data collection and information systems in the states, and as well as really leveraging the use of these highway safety grant program funds. So just a mention of that, and I think with that, I'm not sure you could possibly hear any more about these programs, but I'm going to turn this over to my colleague over at the Governor's Highway Safety Association.
Well, thank you, Dr. Gunnels. And as we said, we will now hear from the Executive Director of the Governor's Highway Safety Association about the different legislative measures that can qualify a state for the National Safety Priority Program funds. Please remember, if you do have a question, feel free to type it into your chat box and send. I will ask as many questions as we have time for at the end of the webinar. And now the floor is yours, Barbara.
Okay. Actually, I just wanted to clarify a couple of things in Maggie's presentation. On the ignition interlock legislation, that has to apply to all offenders. So it's not just repeat offenders, it's got to apply to all offenders. And I think there's something like 14 or 15 states that have all offender interlock laws. With respect to the distracted driving laws, there are two types of laws in the first year. And Maggie mentioned that I'm not sure if everyone got the distinction. There's a small grant where a state can qualify for funding. It's 25% of the overall grant amount, which is about $5.4 million. And all they have to do is have a texting law that is primary. And then in addition to that, there's a larger grant, and the states have to qualify based on a number of different criteria. And there's some statutory language that's problematic, and I'll talk about that in a minute. So Ann, if you could move to the next slide. Okay, so a lot of the incentive grants that Maggie talked about require the states to pass legislation. And it's very, very difficult because the time is so limited. States have already applied for their 2013 grants, so the next opportunity is July 1st for the 2014 grants. So the state legislatures have a very short window for passing legislation or improving their existing legislation in order to qualify for grants. So obviously for the occupant protection grants, a key component is primary seatbelt laws. For the impaired driving grants, you're not required to have sobriety checkpoints, but you are required to do enforcement of impaired driving laws, and obviously sobriety checkpoints are probably the most effective way to enforce impaired driving laws. Again, states need to, if they want to qualify for the interlock incentives, they need to make sure that those are all offender interlock incentive or interlock laws. And for the distracted driving incentive grants, to qualify for the small grants, the states have to pass primary texting bans, which are primary. For the larger grants, the states have to not only pass texting bans and have total bans on the use of electronic communication devices for young drivers, but they also have to require, as part of their statute, they have to test in the driver license exams, they have to have questions on distracted driving, and that has to be a requirement in the state statute, and that's very difficult for most states. And then in the graduated driver licensing laws, the grad licensing incentive program is very complex and has many, many requirements, including a number of requirements that actually NHTSA added through regulation. And I think my opinion is that no state or very few states are going to qualify. And so my recommendation to state legislatures is focus on the aspects of grad licensing laws which are the most important. And my recommendation is that you focus on the passenger and nighttime restrictions. The grad licensing incentive program requires that state laws allow no more than one passenger, and that there be a nighttime restriction that begins at 10 o'clock at night. And we know that every state has grad licensing laws. Many, many states have made improvements in those laws, but not every state have good passenger and nighttime restrictions, and those are the parts of grad licensing laws that have the most impact in terms of protecting young drivers. Next slide, please. So, in addition to the passing laws that will help states qualify for the incentive programs, I've put down some other legislation to address other highway safety issues that aren't necessarily part of MAP-21. And here are three of them. We know that drug driving is a growing problem in the state, and that there is a high prevalence of drugs among drivers. And it doesn't necessarily mean that they're impaired, because we don't really have good research on what's what drugs impair. But we know that this is a growing problem, and we know that there are a couple of things that can be done to begin to address the problem. One is a drug per se law, so that if a driver who's driving erratically is pulled over and they pass the alcohol sobriety test, but they don't pass the drug test, then the DRE test, the drug recognition expert test, that person can be charged because they have any measurable amount of drugs in their system. So it's like an alcohol per se law. If you have drugs in your system, you're considered impaired per se. Very important piece of legislation. And then the other thing that states can do is have multiple impairment charges, so that a person who's driving with alcohol and drug impairment can be charged separately. Right now, most law enforcement officials just stop, and if they found someone who's impaired with alcohol, they won't go any further and test the person for drug involvement. And so it's important to have multiple charges for multiple offenses. Another good piece of safety legislation is booster seat legislation. And in fact, I was thinking about this. It's really important for states to have occupant restraint laws that cover all age persons in all seating positions, so that there are no gaps in the occupant restraint laws. Many states have booster seat laws, and many of them have improved their booster seat laws. But this is one where the state needs to look at the ages that are covered by their occupant child restraint law, and make sure that children up to age 8, and I think it's 64 pounds and 4'9", and make sure that those young children who are not infants anymore or toddlers, but they're young children, and make sure that those are covered by the state's occupant restraint laws. And then, I know this is controversial, but motorcycle helmet laws are the most effective things you can do to address the issue of motorcycle safety. They have been proven. It's a proven countermeasure. But only 19 states have motorcycle helmet laws for all riders. And we think it's really important for every state to pass these laws, especially since motorcycle fatalities have increased every year for the past 14 years, with the exception of 2009. Next slide. So that's really it. Those are my recommendations, and you see the resource information on the slide, and I'd be happy to answer any questions, either during this webinar, I'm sure Maggie will too, or anytime afterwards. Thank you.
Thank you so much, Barbara. As you can see, contact information for both speakers and myself is provided on this slide if you'd like to follow up with any of us. And I also wanted to mention that if you would like to see this webinar again, or if you'd like to see the slides, or if you'd like to suggest it to a coworker, this webinar is being archived and will appear on NCSL's website in a few days. So now I will read the first few questions we have, and I think this could be either for Dr. Gunnels or for Ms. Harsha. First, the question is, does the requirement for GDL distracted driving questions state that the question must appear on the exam, or must it appear in a pool of randomized questions that may be selected to appear on the exam?
Well, as I mentioned, the difficulty is that it can't just be on the exam.
Yes.
It has to be part of the state statute. The state has to require the DMV to test for distracted driving on the licensing exam. And that's that's the difficulty for most states. Many states do test, but it's not part of their state statute.
I absolutely agree with Barbara, and so I think this question is sort of a subset of that question. I mean, the challenge is that it has to appear in the statute. I would think if it does, that this would not be an issue because it's in the statute.
And I would add to that I think this is a quirk of the MAP-21 legislation that we and other organizations will be working to remove in the next reauthorization.
Okay, great. Thank you, ladies. Our next question is, how much grant money would be available if the state passes legislation requiring interlocks for all offenders?
Well, this is Maggie Gunnels, and I just want to mention that, overall, within the Impaired Driving Ignition Interlock Program, there's $139 million available for FY 2013. But, excuse me, I'm going to cough. But to be honest with you, I don't think we can tell you exactly how much money would be available until we know how many states apply. I don't know if I need to be more specific than that, or Barb, if you have any other comments to help clarify that.
I can't remember the number off the top of my head. There's an earmark of it's a percentage of the 139 million.
Oh, okay. It's 15% of the 139 million. So I could tell you in just a second.
Up to that amount will be available. It doesn't have to be that amount.
Yeah, up to that amount. So.
Again, but since since states have to pass all offender interlock, there may not be the NHTSA may not actually allocate that full amount of money because there may not be enough qualifying states.
That's true. So according to a rough estimate, it's between $20 and $21 million total, up to that amount. And again, I think we don't know at this point because we're still in the process of evaluating the application.
Great, thank you. Our next question is talking about how technology is advancing, and do electronic communication devices include only handheld devices? Because new cars are beginning to come with computer-assisted communications, and there's always new gadgets in the cars, it seems like. So is there anything in the law that discusses that?
I think, go ahead, Barb, you can go.
Well, no, I was going to say there's nothing that I'm aware of, and I think the intent was nomadic devices. In other words, devices that a young driver would bring into the vehicle.
Yeah, so it's not specified, but I agree that with Barbara that was the intent.
Great. Okay.
Personal devices.
Our last question is a question, and it's asking about maybe city ordinances and communities. Has any community tried to introduce a motorcycle helmet regulation in a state that does not have a universal helmet law? And the question is, are there any issues that might arise from such approach?
Well, I can just briefly comment. Barb might have more to say. We've had situations for other grant programs, not motorcycle, where states have done only local county ordinances or legislation. Those are not consistent with any of the qualification criteria. So we have had that situation where and specifically to distracted driving. I don't recall one for a motorcycle, but Barb, did you want to comment?
Well, yeah, I can't think of any community that has passed the motorcycle helmet bill, but I like Maggie, we have had experience with communities passing primary seatbelt laws, and in fact, in Kentucky, there were so many communities that passed primary seatbelt legislation before the state passed it that I think something like 80% of the population was covered by the community legislation, and ultimately the state passed a statewide bill because so many people were already under primary belt law jurisdiction in their community. So I mean, it's an interesting concept to pass a community helmet law. I don't think it's ever been done for motorcycle helmets, but we do know that has worked for things like primary belt laws.
Barb, it looks like a colleague from Myrtle Beach, South Carolina, or from South Carolina, says that this did happen in Myrtle Beach, South Carolina, and the court struck it down based upon the state not having one for the motorcycle. But that's the first I've heard, so I appreciate you sharing that.
I mean, you always run into issues of state preemption. So, that's something that a community just has to deal with.
Okay. Well, thank you very much, ladies. And once again, if you would like to see this webinar again or would just like to access the slides, the webinar is being archived and it will appear on NCSL's website in a couple of days. So please check back with us.
Well, thank you for having us, and I hope everyone drives safely, has a great afternoon and morning.